Hello, everyone. Today I'll be joining you from Kazakhstan, where I'm staying for a little bit. It's been a good trip so far. I'd like to make this video for you in which I'll describe Anita Allen's equal protection argument for the constitutionality of abortion. So far in the class, we've looked at many different arguments for abortion, which purport to interpret the Constitution. Today, we'll add another one to the mix, and I'll try to explain to you what it's doing here and its relation to the other arguments that we've studied so far. This week, I won't be available for meeting on Friday, so I'm sorry to say I won't be available for office hours. But if you'd like to meet about the writing assignment or send me a draft in advance of the deadline, please do so, and I'll be quick to get back to you. Today, my basic plan was to review the arguments that have been made so far and then show you how Anita Allen's argument here fits into the picture. We've seen a few different arguments for the idea that there is a constitutional right to abortion. These arguments were that something about a right of privacy generates a right to an abortion, or something from the 14th Amendment and the Due Process Clause generates a right to abortion. Now, how did these arguments go? For privacy, the lineage began really with Griswold versus Connecticut. In Griswold, what you'll find is a protracted analysis of the Bill of Rights and how various constitutional amendments generate privacy rights in different areas of life. The argument is essentially inductive here, which means that it moves from what has been a case or what has been observed in the past to what will be the case in future observations and context. So, how did that argument go? Well, we looked at the First Amendment. In order to properly guarantee a right to peaceful assembly, the Supreme Court held that memberships were protected by a right of privacy. Public organizations or organizations of those who would gather and peacefully assemble, their membership lists are considered private. There is a kind of restricted access that the government has to membership lists because without such privacy, the right to peaceful assembly would be inhibited. Likewise, in the Third Amendment, what one finds is a guarantee that during a time of war, one has a right of privacy in their home. Soldiers can't be quartered there. You have a right of physical privacy in your home. In the Fourth Amendment, this right broadens even further. One has a right against unreasonable searches and seizures in one's person, papers, house, and effects. And this implicates various dimensions of privacy as well, particularly informational and physical privacy. Likewise, in the Fifth Amendment, when we receive a guarantee that we can't be compelled to testify against ourselves in a court of law, this implicates a kind of informational privacy. And the Ninth Amendment, in Griswold versus Connecticut, was interpreted to mean that there are rights that haven't yet been written down or protected explicitly by the Constitution, but that no kind of constitutional interpretation should be such that it precludes the possibility of there being other such rights that do enjoy constitutional protection. And so from all of these instances in the Constitution, it looked like in Griswold versus Connecticut, at least, there's a kind of privacy that might apply to decisions about whether to have children and ways that you might prevent that via contraception. Now, Roe versus Wade merely extends that line of reasoning to say, look at all these past cases of privacy. Won't there be in the future a right of privacy in abortion as well? That's the kind of argument from Roe versus Wade. Now, what exactly are the weaknesses of Roe versus Wade? Well, you might worry first about an inductive failure. Sometimes inductive arguments seem very good. Suppose that you've seen 4 Honda Civics in a row. How likely is it, or how reasonable is it, to assume that the next car will be a Honda Civic, excuse me. The example is just supposed to be, you've seen 4 cars of the same kind all in a row. Is it a good or reasonable thing to think that the next car you see will be a Honda Civic too? Maybe not. But sometimes inductive reasoning seems very strong. Think about the number of crows you've seen in your lifetime. Some other kind of black bird, right? All the crows I've seen so far have been black. Therefore, the next crow I see will probably be black too. It seems like a reasonable thing to think. When you compare the black crow case to the Honda Civic case, something is different between them, given the number of cases, right? Sometimes inductive inferences can be strong, sometimes they can be weak. And think again about the Supreme Court. That argument was that I've seen privacy rights attach in these various contexts. Therefore, there will be other contexts in which these rights might probably attach as well. How strong is the inference? Well, it seems doubtable. It seems rationally doubtable whether these privacy rights might extend to other interesting cases, such as those involving contraception or abortion. Another way in which you might doubt the privacy argument is just that privacy has different senses in some of the cases that were the basis for the inductive generalization in the first place. In other words, when you look at the Constitution, you'll find physical and informational privacy guaranteed in various contexts. But it seems like Griswold versus Connecticut and Roe versus Wade extended that kind of privacy to something else that really didn't seem like privacy at all, this kind of decisional privacy. And so there's a second reason for doubting privacy arguments that I've talked about in this course. One is just the inductive failure. How good of a basis is this for a generalization in the first place? The second kind of argument is that the things that we're basing our inductive generalization off of seem to be privacy in a different sense. These look like informational and physical privacy, but what we really need to support the decision in Griswold and Roe are kind of decisional privacy, in which one has a right to make a decision free of unwanted encumbrance or imposition by other people. It doesn't really look like privacy, according to the first piece we read by Anita Allen. And it seems to me that the Supreme Court has historically been sympathetic to the worries that I've just raised. And I think because of these worries that perhaps abortion wasn't properly grounded in the reasoning from Roe versus Wade, the Supreme Court they reworked the reasoning in Planned Parenthood versus Casey. And what did they do there? Well, in that case, they looked at the 14th Amendment, and the 14th Amendment guaranteed that one may not be deprived of liberty without due process of law. The argument in Planned Parenthood versus Casey is kind of two-part. The first part is that the term liberty in the 14th Amendment just extends to include abortion. And the second part of their argument is that stare decisis militates in favor of keeping the essential holding of Roe versus Wade, which just means the constitutional right to have an abortion. Okay, well, what is the defect, or what are the reasons to doubt the substantive due process argument given by the court in Planned Parenthood versus Casey? Well, for that task, we read Dobbs versus Jackson. Dobbs versus Jackson says that if you say that something is a liberty guaranteed by the 14th Amendment, then one incurs a certain burden to show how that practice or that behavior is grounded in the nation's history and tradition, or actually they use the term "and," which is controversial, and implicit in the concept of ordered liberty. But they then go on to show that rights to an abortion don't seem to be very much grounded or rooted in the nation's history and tradition. And so there was, on that basis, a reason to doubt that the reasoning was sound. Now, one thing that I flagged as controversial about the criticism found in Dobbs versus Jackson is that another part of the Dobbs decision castigates the Planned Parenthood versus Casey court for an unreasonable reliance on the doctrine of stare decisis. Remember that when one appeals to stare decisis, one is saying something like, these cases have been decided this way before, so we'll do it again here. Dobbs stood for the idea that stare decisis is not an inexorable command. It's oftentimes followed on an ad hoc basis. And sometimes when one appeals to stare decisis, one is engaged in a kind of arbitrary reasoning. What bothers me somewhat about this Dobbs criticism of Planned Parenthood versus Casey is that the court then turned around and preempted a certain species of argument because of what had been decided before. And what had the Supreme Court decided before? They had decided that it was not an invidious discrimination against women. It was not an invidious form of discrimination against women to ban abortion at certain stages, and presumably at all stages. And so this looks to me like they are appealing to doctrine or stare decisis to preclude the possibility of an equal protection argument for the constitutionality of abortion. And why is that significant? Well, not so much in the Supreme Court, but more in the legal literature and scholarship. One often finds reference to an equal protection argument for abortion. And so what I'd like to do in the rest of this lecture is to explicate that equal protection argument for you. And why am I doing this? Well, it has occurred to me that I seem a little bit critical of some of the reasoning for the constitutional right to an abortion. And people will probably be split on whether these arguments are good or bad. And I don't mean to give anyone the impression that I've said all there is to say about these things. There are many arguments for the constitutionality of abortion that I simply won't engage with in this course because I don't have time. But this is, to me, the strongest and most interesting argument for the constitutionality of abortion. And so I think it's of interest for us not simply to see some arguments that might fail, but also some arguments that might be good. And maybe think about them. And I will ask you explicitly on the next writing assignment to consider whether the legal reasoning for Roe versus Wade could have been strengthened or improved, or whether it was defective, and whether you'd like to do that in a particular way, which might include appeal to the Equal Protection Clause. So I'd like to make sure we're all on the same page here. I've assigned in this class 2 distinct pieces from Anita Allen. One of these pieces stands for the idea that the term privacy might be used equivocally, even in decisions like Roe versus Wade. And this piece is a piece that does a couple different things. One thing that Anita Allen does is she gives this equal protection argument for the constitutionality of abortion. The second thing she does is try to target a specific kind of advocate for the equal protection argument. More particularly, Anita Allen's approach is going to be additive rather than fixative. And what does that mean? The additive approach to abortion rights is to say, look, there are many different ways of arguing for abortion rights. We really shouldn't be taking a stand on which of these ways is the best. What we ought to do is just throw everything at the Supreme Court, including the kitchen sink. We should advance abortion however we can, and if the privacy arguments are such an avenue, we should appeal to them. So this one kind of abortion advocate prefers to advance any particular argument that would promote the goal of securing abortion rights because it's very important. The other kind of position, which she calls a fixative position, says in essence, look, there is one best kind of argument for the constitutionality of abortion, and really we ought to be leading with the best argument. And these people that she's targeting in this article say that the equal protection argument is superior to other kinds of arguments for abortion. One thing that Anita Allen says at the end of the article, which I find rather insightful, is that it might only seem like the equal protection arguments are superior because they haven't quite been as much picked over or analyzed or thought about to death, because they're not as popular and they're not as common, and perhaps most people haven't heard of these before. I'm sympathetic to that remark from her. But overall, what you'll find maybe past page 18 or so of this reading, I find particularly uncompelling and weak against the fixative position, not because there aren't good things to say against the fixative position. It's just that what she says seem to be kind of straw men. They seem to be kind of straw man arguments. And so whenever you attribute to your opponent something that's probably a little bit weaker than what they'd actually endorse, you're going off on the wrong track, I think. So just to edify us all and kind of make sure I'm using my time most wisely in this course, I don't think I'm going to look at Anita Allen's criticisms of the fixative position. Remember that what she'd be criticizing there is just the idea that there is one and only one best approach to justifying abortion by appeal to the Constitution. Anita Allen disagrees. She says, however, you want to argue for abortion, you should do it. Don't just appeal to one argument, but the criticisms there are just a bit weaker for reasons I'll get into maybe in just a moment. For now, let's take a look at what exactly her argument will be. She starts with the basic idea that she derives from these feminists that American citizenship, quote, entails the equality of political rights and the dignity of work and personal achievement. So on this picture, what it is to be an American citizen is to have certain rights, among which are included the right to achieve things that you want to achieve. If you want to become a doctor, then part of what it is to enjoy full citizenship is to have the ability to become a doctor. If you want to become a lawyer, similarly, what it is to be an American citizen is having this ability to pursue that achievement, to pursue that thing that you find worthwhile, to pursue that thing that you find contributing to the good life. Now, one thing about pregnancy that we can add to the picture here is that pregnancy can detract one from, can inhibit one in the pursuit of their goals, right? Perhaps that's the best way of saying it. Pregnancy can inhibit one in pursuit of personal achievement. And notice that this is a feature only of those who are capable of becoming pregnant and not so much males. And so males, it seems, enjoy a kind of effortless citizenship, particularly, says Allen, the white, affluent, heterosexual Christian males. Those people have life in the palm of their hand, as it were. They have it going on. They have an effortless form of citizenship in which they can pretty seamlessly pursue their goals. If they want to achieve something, not much stands in their way. But for women, for females, there's always this looming risk of pregnancy that looms over them, that could detract from and inhibit them in the pursuit of personal achievement. And so there is an inequality between males and females, especially with respect to their standing as citizens. And because the Equal Protection Clause of the Constitution prohibits there from being invidious discriminations against a subclass of citizens, measures ought to be taken to restore that equality. So let's look at the kind of hokey way I've cashed out the equal protection argument here. Basic idea is that being a U.S. citizen entails that you can pursue personal achievement, but since males can pursue this personal achievement more easily than females, there's something that is needed to equalize that inequality. And since abortion is the sort of thing that could equalize the inequality, abortion is a sufficient condition for restoring equality. That's the argument. Females are second-class citizens, according to Allen, without abortion rights. Abortion rights are needed to restore their status as first-class citizens, those who are capable of acting, well, like males. They're able to seamlessly pursue their goals and achieve their dreams. I don't have as much to say about the equal protection argument, probably because of what I've said before, and that is it's just not as often thought about. It's not as often discussed. But one way I've thought of that you might push back is by noting that there are lots of different ways of equalizing the inequality. And one of the ways relates to the burdens of care that we have imposed by our own culture. Sort of interesting, right? It seems to me, maybe this is wrong, maybe you thought the same, maybe you felt differently. But to me, the way it seems to me is that in this society, when a couple or a woman or a female has a baby, it's often expected that the female will incur the burden of care for the child, right? But is that a contingent social fact, or is it something that needs to be the case or will be the case in every kind of imaginable culture? I can imagine a culture in which the expectations are a bit different. Suppose a female becomes pregnant and carries a child in a different culture, one that differs radically from our own. And then suppose that in this culture, it's expected that the male parent take care of the child, stay with them, nurture them, do all the things characteristic of a mother in our society, right? Now, in that society, it wouldn't, to me, seem like the female parent serves to be disadvantaged by pregnancy. Perhaps there are the physical ailments associated with pregnancy itself, but as concerns the care of the child and whatnot, those burdens would fall on the males. So it looks to me like a contingent social fact that there would be these burdens of care in society. And so one thing that you might think about the equal protection argument is that there are multiple ways of equalizing the inequality. One way of equalizing the inequality would be to let females be just as free as men, as males. But the other way you might think is that you could actually just burden the males, right? If you burden the male to the same extent that females are currently burdened when they undergo pregnancy, it looks to me like you could restore the inequality. Males and females would be equal in that respect. They would both be similarly burdened. And so that's an interesting thing to think about with respect to the equal protection argument. I can't say I know exactly what to do with this remark or how it would apply. There's something interesting about it. There are multiple ways to restore inequality when it exists. One of the ways is just by transferring a burden such that the burdens are approximately equal. Provision of abortion-related services seems like it's not essential to restoring equality. So that's perhaps one of the weaker points of the equal protection argument. Again, I don't think it's a very weak point, but it is sort of a troublesome enough remark for me that I'm worried about it. And maybe you are too. Okay, now in the rest of this lecture, I'm going to quickly fly by what I take to be one of the most salient criticisms of the fixative position. The fixative position in this article is represented by Cass Sunstein, who is famously a proponent of the equal protection argument, and Anita Allen takes issue with his insinuation that the equal protection argument enjoys a kind of superiority to both privacy arguments and those arguments such as those found in Planned Parenthood versus Casey, like substantive due process or something like that. The main argument that these people advocating for the fixative position will lead with is that the term privacy is used equivocally. So just as Anita Allen described in her previous article, proponents of the fixative position think that privacy is used equivocally. And the amendment secures informational and physical privacy, but in Supreme Court jurisprudence and the constitutional law, privacy means something like decisional privacy, which is honestly unlike the other two things. And so since privacy is being used equivocally, we should forego the notion that privacy has anything to do with abortion. Now, Anita Allen criticizes this argument at the very broad and vague level at which I just expressed it, that privacy is not connected to abortion. She says, of course, privacy is connected to abortion. Every time one becomes a mother, one forgoes all sorts of physical privacy. And this is true in my own personal experience. My daughter always wants to follow my wife into the bathroom and whatnot. You forgo so much physical privacy. You have to feed children in public sometimes, and it's a nightmare. It's a mess, and it's you really forgo a lot as a parent. And no one could reasonably deny that when one becomes a parent, particularly a female parent, one forgoes a lot of their personal privacy. But it seems to me that this is kind of a red herring, because no one in the fixative position should be advocating for the idea that privacy has nothing to do with considerations about parenthood and abortion. All they mean to say is that considerations about privacy found in the United States Constitution do not provide the kind of premises we need to derive properly a conclusion about the constitutionality of abortion. There exists, in other words, no sound deliberative route between the amendments of the Constitution and the conclusion that privacy is that abortion is grounded in the Constitution and protected by something in the Constitution. Okay, so this has been a lot, but the basic idea here is that Anita Allen represents this position that you should use any and all arguments to secure abortion, which is an important human right. The fixative position basically focuses on this equal protection argument involving the subordinate status of women. And it says that this argument, this equal protection argument, is the strongest kind of argument that one could use and attempt to secure abortion rights. Anita Allen protests that even though it's a good argument, even though she favors it and she thinks it's the best, you shouldn't discard the other arguments. And then what maybe follows is a rather weaker attempt to justify why one should appeal to any kind of argument. And she does so by kind of criticizing some vague statements from those in the fixative position. So I hope that elucidates the material for you. The next lecture that I'll post soon, I'll just walk you through the second writing assignment so that you can feel confident as you approach that. I do hope that you'll send me drafts of your writing assignment so that, if you didn't get the grade you wanted on the first writing assignment, we can take life by the horns and get you back to where you want to be. So I've really appreciated this class so far. It's been a quiet class, nothing much to do, but the material is as interesting to me as it's ever been, and I hope you enjoy thinking about how to interpret historical documents, because this has been one of the most interesting kind of legal forms of argument that you'll encounter in real life. And so I hope you're well until the next lecture. Thanks.